Hello, everyone. Good evening. Happy Thursday. I'm immigration attorney Yael and so happy to be here on our first live show of 2024. I hope everyone had an amazing holiday season with your family and loved ones, and that you had a wonderful new year. And I'm excited to be here to answer your immigration questions. I go live every week on Thursday at 5:30 Pacific, and I answer questions about immigration. So folks send me questions during the week, and I pick the ones I think would be the best or the most interesting for everyone, and I answer them live. So if you're here for the first time, hello. If you're joining us, thank you so much. If you're new, feel free to like like us on Facebook and subscribe on YouTube so that you can get more notifications about events like this. Okay. Hi, Samuel. Nice to see you here. Thanks for being here. I hope you're doing well. Perfect. So as I said, I'm going to answer immigration questions today. If you are watching this and you have a question that you want me to answer live, feel free to write your questions in the comments, and I will try to get to them as we go. Also, if you're watching the recording of this, you can also feel free to write your questions, and I'll get to them later. Okay. Also, just to know that everything we say on the live show is general information, so it's not considered legal advice. But if you do want to get a personalized consultation for your case, feel free to reach out to us at this number. It's kind of going here on the screen. We have a team that can answer your calls and book you guys a consultation if you want to have a one-on-one consultation with me. Perfect. So I am going to jump right in to some of the questions. We have some interesting ones today. So every week we have interesting ones, but I really like the questions from this week. Okay, so what is considered a red flag for a marriage green card? Great question. So a marriage-based green card is basically a way to become a lawful permanent resident, right? Based on marriage to either a US citizen or a lawful permanent resident. Now, when you're applying for residency or a green card based on marriage or based on a relationship, it is your burden as the applicant or the beneficiary to show that the marriage or the relationship is real, it's legitimate, it's what's called bona fide in the more technical language. So you have to show as a petitioner, as a beneficiary, that you are in a real relationship. Now, certain situations are considered quote unquote red flag situations. Okay, they're considered situations or cases where immigration might ask more questions and might interview the couple in different ways. Okay, so for a certain red flag or any more special or unique situations, immigration might separate the couple at their interview and do what's called, we call it a Stokes interview, basically separate the petitioner and the beneficiary and ask them each the same questions and to see, if the answers are similar. Okay, so what is considered a red flag? So, and it's important, before I even say what's considered a red flag, it's important to know that even if you have this quote unquote red flag on your case, it doesn't mean that you cannot win your case, you cannot be approved for a green card. Not at all. It just means that your case might be scrutinized a little bit more, that you might get a little bit more questions, and the questions will be asked in a different way. Okay. So certain things that are considered red flags are, for example, a big age difference between the petitioner and the beneficiary. Okay, if you have 10 years or more of an age difference, this can be a red flag, can cause some questions. Okay, if you're in different cultures or different religions, okay, it can make an officer a little curious about your relationship, right? If it is a same-sex marriage where there was previously uh, um, other sex marriage, right? It could be it can cause a red flag. Okay, things like that. Those are the most common ones. Others are if you previously petitioned someone for a green card and now you're petitioning someone else for a green card and it's not been a long time between those two petitions. That could be considered a red flag. So what do you do if you have a case where there is an age gap or there is a huge like a big cultural difference or religious difference between the petitioner and the beneficiary, between the couple? So in that case, you don't have to worry. It's not the end of the world. You can still win your case. But my recommendation would be to really prepare for your case and submit a lot of documents of joint relationship, right? So as many documents, as much proof as you can to show the relationship is valid and real. Okay, so if you have pictures, affidavits from friends and family, joint bank accounts, if you're living together, go on your lease together. If you can be on each other's insurance policies, if you can be on utility bills together, car registrations, Costco memberships, anything that you can think about, do it. Okay, so the more documents, the better. Now, if you're called for an interview, I definitely recommend to prepare for the interview, to consult with an immigration attorney, to have a preparation session before your interview so that you can practice what kind of questions, you can know what kind of questions you might be asked, and you can practice answering these questions. Okay, in certain situations, the couple, like I said, would be separated, and it can be really nerve-wracking or worrisome when you see that you get separated and you're asked questions separately. So knowing that this could happen and practicing it is a great way to prepare, okay, and to increase your chances of success. Okay, so those are some of the red flags and what to do if you have quote unquote a red flag. Perfect. Okay, Samuel, thanks for asking. Let me read your question, okay? I completed the I-130. My wife has been to the US previously in 2018. She's Colombian and lives in Bogota. The visa is no longer valid. Am I required to send an I-90 with the I-130? Okay. But most of those are not possible if we live in different okay, so that's just a comment. To your question, you don't need an I-94 if she's living outside of the country. Okay, it's not required for the I-130. Okay, it's only required if you're here, if you're filing together with the I-130, also an adjustment of status, then you would need to show that she has, entered legally, and you can show that with the I-94. Okay. So about the joint documents, you're saying most of those are not possible if we live in different countries. For example, my wife lives in Colombia. I visit often, but really difficult or almost impossible to have anything joint. You're right, definitely. And the consular officers know that. So it's different when you're doing consular processing, when you are processing a marriage case when the beneficiary is outside of the country, or if you're doing the case here in the United States. Okay, it's a different process completely. So when you're in abroad, usually the interview is just the beneficiary. It's not with the petitioner. And also it's known that certain evidence wouldn't be existent, right? So you're not living together, so you don't have a joint lease, right? You haven't filed taxes together because she's not living here yet, right? But in those cases, we do pictures, we do correspondence between you two, visits, if you flew over to Colombia to visit her, affidavits from friends and family, okay, things like that. If you indicated here in the United States that you are married, right? So certain places you have to indicate your marital status, like for example, at work, if your employer requires you to fill out a form, or your HR and they ask you what's your marital status, then you should show that you are married. Okay. Perfect. Also on your tax return, you should write that you're married, right? You're filing separately. You're not filing with her because she's not here, but you should write that you're married. So those are stuff that you can submit as proof. Perfect. Good. Good. I hope you have quick processing for your case and your wife can come here as soon as possible. Awesome. Let's look into some other questions. And if you're joining us now, welcome. It's so nice to see you guys. Thank you so much for being here. If you have any questions, feel free to write them in the comments, and I promise to get to them as you go. You're welcome, Samuel. Perfect. Next question is, can you explain about DACA Advanced Parole? Yes, I can definitely do that. So DACA stands for for Deferred Action for Childhood Arrivals, and it's available for um, certain people that meet specific criteria, so that they've arrived to the United States before the age of 16. And they've been maintaining their presence here in the United States. It's no longer possible to file for DACA, for new DACA cases. I mean, you can still file for them, but immigration is not processing DACA cases right now because it's currently on hold. So while we can file DACA cases, they're not going to process them yet. What they do process and what you can do is you can file for advanced parole. So DACA advanced parole is a special benefit that is available for people that already have DACA, and it allows them to ask to travel, to leave the country for a specific reason. So this reason could be either educational or humanitarian or financial, right? So you have to have a specific reason to leave. Now, if immigration grants you this permission, this advanced parole, immigration is basically allowing you to leave the country and come back. Okay, it's not guaranteed, but it's very close to guaranteed to come back. Okay, and this is a huge thing because if you are on DACA, that means you're here and you have a work permit and you have a social security number, but you don't have a visa, right? You can't travel outside of the country in and out. You have to ask for permission for this. Now, if you get permission and you have this reason, immigration approves it, and you leave and you come back, then your last entry is lawful. And a lot of DACA folks don't have that lawful entry. So with a lawful entry, you can do a lot down the road, right? So down the road, if you happen to marry a US citizen, then you might be eligible to file for your green card in the United States, okay? Because that advanced parole gave you that entry. So DACA advanced parole is a great option. I really encourage anyone on DACA to try for it. To get the advanced parole, to leave and to come back. And it is a good option for the future. Okay. Perfect. Okay. Let's jump to the next question. Okay. This is about naturalization, so about citizenship. Can I apply for citizenship if I've traveled a lot outside the country? Okay, so if you're a lawful permanent resident and you've had your green card for 3 or 5 years, then you can apply for naturalization to become a US citizen and get your US passport. To become a citizen, to file for naturalization, you have to meet certain requirements, right? So you have to show that you've had your green card for a certain amount of time, and that you've been in the United States residing here at least half of the time. Okay, you have to show that you've been here the last half of the time, and that when you left the country, you haven't left for extended amounts of time. Those requirements are the continuous presence requirements and the physical presence requirement. So continuous residency and physical presence are those two requirements combined together. And it basically means that you have to be, like I said, living here at least half of the time. So if you're applying based on the 5 years, at least 2.5 years you've been here in the United States. And that you've not left for an extended amount of time, usually more than 6 months. Okay, so if you're not sure if you're eligible or not because you've had a lot of travel outside the country, I recommend to have a consultation. Reach out. We can help you assess if you're eligible or not. Okay, because if you're not eligible, you don't meet the day test. It's very particular, so you have to meet exactly half of the time, 50% of the time here on the day. So if you're not sure, then feel free to reach out to us, and we'd love to help. Okay, so if you've traveled a lot, you might still be able to apply. Just double check to make sure. Okay. Perfect. Okay. Samuel, you thought of two more questions. Okay. We have children from previous marriages. Added her kids to the I-130 because it asked about other family. Do I need to add the birth certificates of children or leave them off on the I-130 if I'm not petitioning them? So you have to list all of your kids. So you can list all of your kids, including the stepkids. Your stepchildren, which are your wife's children. You do not need to add their birth certificates. Is there a visa or something we can complete that will allow my wife to wait here while the I-130 is processing? So that's a good question. And actually, yes, there is something like that called the K3 visa, which you can apply for while the I-130 is pending. The thing about the K3 is that while theoretically, it's a nice concept. You can apply for it and use it to enter the United States while you're waiting. But practically, it's not really helpful because it's only valid while the I-130 is pending. You can only ask for it while your I-130 is pending, and it takes as the same time as the I-130 takes to get processed. So it's not a lot quicker. So usually there's not much to do while the I-130 is pending. Okay. Perfect. I hope that was helpful, Samuel. Dylan is asking for K1 visa holders who wish to file for adjustment of status. Are they required to be in the US for the entire duration of the processing times? Awesome. Thanks for the question. So when a K1 enters the United States, they have 90 days to get married. And then after they get married to their US citizen petitioner, they can file for their green card through the process of adjustment of status. Okay. When they file their adjustment of status application, they can also file for a travel document, okay, also called advance parole. So they are required to stay in the United States until they get the advance parole. Okay, so there is going to be a period of time where the K1 has to be in the United States, just after filing the adjustment of status and before receiving. They cannot leave until they receive their advance parole, and that can take anywhere from 3 months to 6 or even 8 months to get the advance parole. Okay, so the goal basically would be to file for the adjustment of status as soon as possible, because with the adjustment of status, you can also file for the advance parole for the travel document. Okay, and once you get the travel document, they can travel outside the country. Perfect. Thanks for everyone joining and for your great questions. If you have any questions, feel free to write them on here in the comments. And if you're watching this in recording as well, I just want a quick reminder that you can still ask questions. Okay. Perfect. You're welcome. Okay. Can I get the 10-year green card if I'm divorced? Great question. So if you file for your green card based on marriage and the marriage was less than 2 years old at the time that you get your green card, then you will receive a conditional green card. You'll receive only a 2-year green card. And then prior to the expiration of your 2-year green card, you have to file something called a removal of conditions application. So you have to ask to remove the conditions on your green card so that you can get the 10-year permanent green card. Okay. Now, what happens if you are in the process, you have not filed for your 10-year green card yet, and you are getting divorced or you have divorced? So the good news is that yes, you can still get your 10-year green card even if you're divorced, because the process of the removal of conditions allows for a waiver of the joint filing. So generally you have to file it together with your petitioner jointly. But if there are exceptions, and one of those exceptions is divorce. So if you are divorced, you can file a waiver of the joint filing. Okay, you still have to prove that the marriage was real, that the marriage was what's called bona fide. You have to show proof of the joint relationship, but it's still possible to file even if you're divorced, even if you do not have your petitioner sign off on it. Okay. Jumping in, I'm going to take 2 more questions for today. So if you have any questions, this is the time if you want me to answer it before today. Okay. Can I apply for a VAWA green card if I entered illegally? Okay. Awesome. Super good question. So if you guys follow me, you know that I talk a lot about VAWA. VAWA stands for Violence Against Women's Act, and it actually applies to men exactly the same way, even though the name says woman. Okay. And it is a way to get a green card, to self-petition for your green card without help of anyone. If you have been in a relationship where you suffered from extreme cruelty or abuse by a US citizen or a spouse or resident spouse. And there's also an option to file for VAWA based on abuse or cruelty of children that are over 21 and are US citizens. Okay. Now, one of the good things about this option is that it's a very forgiving option, and it allows you to apply for the green card here in the United States, even if you've entered unlawfully. Okay, and for those of you that don't know, if you've entered the country without a visa, without an inspection, then you are not eligible to file for the green card here in the United States, and you have to go back to your home country. And leaving causes all kinds of different consequences, like bars to re-enter and waiver requests that are required. So one of the great things about VAWA is that it does allow you to file for your green card here in the United States, even if you entered unlawfully, even if you've been here, you've overstayed. Maybe you entered unlawfully and you overstayed for many years, even if you've worked without authorization. Okay, so it's a very forgiving, and don't be discouraged if your situation is that you entered illegally and you think you qualify for VAWA. Okay, if you do, please reach out to us. We'd love to help you about and be there for you. Okay, perfect. Okay, Samuel, there's no way to avoid consulate interview. Those are regularly scheduled because you do need to get a visa, and for marriage-based cases, it's required. Okay, last question for today. Okay, this is a long one. I just got my green card and now plan on petitioning my parents and younger sister. How long do I need to wait to petition them? Well, first of all, congratulations on becoming a resident. I know how difficult and challenging and long the process can be. So great, great, great. I'm so happy for you. And I'm really happy that you're considering petitioning for your family members. And it's great. The only thing is that when you're a resident, you cannot petition for your parents yet. So you would have to first become a citizen through naturalization, and then you could petition for your parents. Okay, so green card holders are only allowed to petition for their spouses and their children. You can petition for children of any age as long as they're not married. Okay, so when you become a citizen, okay, you can petition for your parents and your sister as well. Now, if you received your green card based on marriage, then you can apply for citizenship 3 years after you got your green card, your first green card. So even if you had a conditional green card, you can, it's 3 years after you got that conditional one. Okay. Now, once you're a citizen and you want to petition for your parents, you would petition for your parents. Parents petition that's considered an immediate relative. There's no wait other than processing times, and you can bring them here. Your sister is a little bit of a different story. Sibling petitions are available. However, there is a very long wait for those. Those are not considered immediate relatives. Those are what's called preference categories, and that can be 15 years or longer. So usually what we suggest is to consider having your parents that are now residents, when they are residents, apply for your sister. Okay, so this is a process that will take several years in your family because first you have to be a citizen, right? But definitely down the road, both your parents and your sisters would be able to immigrate to the US. Okay, and priority dates and things like that change every month, so it's a good idea to keep following and seeing what the processing times are and the priority dates are. Okay. Wonderful. Well, thank you so much, everyone, for joining today. Thanks for questions. It was a pleasure being here. I'm going to be here next week as well, Thursday at 5:30, and I'm here to answer your questions. Send us questions over the week, and if you want to write questions here in the comments, you can do that as well. And I will see you soon. And in the meantime, have a wonderful weekend, a wonderful week. Stay safe and healthy, and see you soon.